one more thing. Okay, good deal. Okay, I got everybody up and seeing everybody's nice, bright, shining faces. For just the record and for the YouTube channel, obviously this is being conducted on the Zoom teleconference application and being broadcast live on the 506 YouTube channel. You ready, Ms. Wiley?
Yes, sir.
This is cause number CV22-0-6-0494. Angelia, Angelia, Dunbar, Dunbar, individually and as a shareholder and director on behalf of PV Asset Management Incorporated versus Dennis R. Bolding, Bolding, and Charles E. Williams, Jr., DBA MEZ, MEZZ Fund 1, LLC. Who's here on behalf of the plaintiff?
Respectfully, Your Honor, my name is Yao Edubofo. I appear for the plaintiff.
Okay. Could you spell your name for the record?
Yes, Your Honor. My name is spelled Yao. The first name is Yao. It's spelled as Y-A-W. My last name is Edubofo. It is spelled as A-D-U-B-O-F-F-O-U-R, Your Honor.
All right. And who's here on behalf of, I guess, defendant?
Good morning, Your Honor. Jordan Curry from Munch Hart on behalf of Mr. Bolding.
All right, Ms. Curry. And we have some other people that are on here. Ms. Wise?
Yes, Your Honor. I'm also here for Mr. Bolding.
Okay. And I assume the Angelia is the plaintiff. Is that correct?
Right, Your Honor.
All right. I think that's everybody. We have a Dennis not showing up, but I see that they're here. Is that the defendant?
Yes, Your Honor. That's my client, Mr. Bolding.
Got it. Okay, so we should have everybody here. It's my understanding we're here on defendant's rule 91A motion to dismiss. So we can just kind of jump right in there. I guess, Ms. Curry, you want to go ahead and start? Are you going to be calling witnesses or just going to be making arguments?
I have a brief argument on the motion, and you probably saw in our motion we are requesting attorney's fees. I'm happy to address that later on in the hearing. However you prefer, I can put on testimony or we can submit that otherwise. But I defer to you on how you prefer to handle that.
I'm easy either way. As far as, but you don't need me swearing any witnesses in. Is that correct? Or just your
if you want to do
client?
not my client, no, sir, but perhaps my colleague, Ms. Wise.
Oh, okay. Well, y'all are officers of the court, correct?
That's correct.
All right. I mean,
Yes,
I'm good with it, but we can be safe and sorry. All right, Ms. Wise, if you raise your right hand, you swear to tell the truth, whole truth, nothing but the truth, ma'am.
Yes.
All right. You may put your hand down. Okay, Ms. Curry, you may begin.
All right. Thank you. Again, for the record, my name is Jordan Curry from Munch Hart on behalf of Mr. Bolding. I'm joined by my colleague, Kelly Wise, as well as my client, Dennis Bolding. Before I get started, Your Honor, I have a PowerPoint that I would like to share during certain portions of my presentation that actually Ms. Wise would share if the screen sharing function is enabled. If not, I'm comfortable proceeding without it. But if we could get that enabled.
It's been a while. I went live and I haven't done a Zoom hearing. Man, I bet it's been 6 months. So I used to be pretty good at it. Let's figure out if I can do this here. Let's see. One participant can share at a time. I think we're good. Let me see if I can get that going. Is that, I got my stuff up. Let me get rid of that. So let's see. Okay. Can y'all see my screen? Is it up?
We can't.
Can't. Okay. All right. I'm trying to see how I can share your screen. Maybe my coordinator is going to help me out. This isn't right. Hold on. Like I said, let me get rid of it.
Like I said, we can proceed without it. It's only 2 slides. If it's too much trouble, then we don't really need to worry.
Hold on just a second. Is this her?
These are all of yours.
Okay.
I would think you can go there.
Okay, let's try this. Does that work?
Yes, we can see your screen now.
All right, now how do I get it to you? All right. Let's see, participants, right? Okay, so I'm gonna try this.
Oh, that's a
Nope.
chat.
Never mind.
Okay, I think you need to,
Oh, here
Yeah,
it
click
is. Yeah, maybe not. Like I
you're
said, it's
sharing.
new share. Yeah, let's see, it hasn't come to me. Been a while, like I said, since we've done this. Well, we might just have to. That's where I was.
Maybe you have to stop sharing and let's try it again.
We're gonna try one more thing, and then if this doesn't work,
Sure.
How about the arrow? There.
go here.
That should be correct.
Who can share? Maybe that's the problem.
What is the arrow and participants? Okay.
All right. Well, I
Let's
apologize.
try.
It's been too long since I've done
Yeah.
this. Yeah, this is just.
Yeah.
And another reason, like live participation. All right. Sorry. My
No worries.
my Aggie skills are in full force here. So, okay, go ahead.
No worries. And you're in good company. I'm an Aggie myself. Well, again, we're here today on a Rule 91A motion to dismiss plaintiff's trespass to land claim. As you probably saw, since we filed our motion, plaintiff filed an amended petition, but the factual allegations and the trespass claim itself have not been amended since in that new petition. Because there's no basis in law or fact for plaintiff's trespass claim, it should be dismissed under Rule 91A.
So I just want to make sure we're just talking about the trespass at this point. All the new allegations in the new amended petition, you have no issue with today. Is that correct?
Today, that is correct.
Okay.
We're proceeding only on the trespass claim.
Got it.
And as background, Your Honor, this dispute is not new. Plaintiff filed a lawsuit on these same factual allegations in January 2022 in Dallas County District Court, and that was referred to arbitration. But after plaintiff received a few unfavorable rulings from the arbitrator early in the proceedings, she ultimately dismissed the arbitration and dismissed the Dallas County lawsuit in June of 2022. And 3 months later, she filed her original petition in this court, and now we're here. And pertinent to the trespass claim in particular, plaintiff's allegation.
Real quick, is there a venue issue at all, or you agree that it should be here as well?
We believe that the trespass claim is properly before the court. We are evaluating what our next steps would be. The motion to compel arbitration in the Dallas County Court was filed by a co-defendant, and we didn't oppose it. Like I said, we're evaluating what our next steps are. With regard to the venue or your jurisdiction, there are no issues. And the existence of an arbitration clause doesn't deprive this court of jurisdiction.
Got it. All right, I'll try to leave you alone now and let you go. All right, go ahead.
Sure, no worries. I'm happy to answer questions. So, like I said, pertinent to the trespass claim, we've got 3 relevant allegations. First, plaintiff alleges that she and Mr. Bolding were equal shareholders in a company called PV Asset Management, which owned approximately 30 acres in Waller County. And that can be found at paragraph 10 of the second amended petition. Second allegation, is that she alleges sometime in 2019, she transferred all of her shares in the company to Mr. Bolding. Again, that's paragraph 10. Third, she alleges that Bolding later transferred all the shares in the company to the unserved defendant, Mez Fund 1 LLC. And that's in paragraph 14 of the second amended petition. And the trespass claim, in that claim, she alleges that the transfer of the shares by Mr. Bolding or by the company constitutes a trespass on the property. And this claim legally fails for 3 reasons. The elements of a trespass claim are first, that plaintiff owns or has a lawful right to possess the land. Second, that the defendant enters the land physically, voluntarily, intentionally, and without authorization. And third, that the defendant's entry causes injury to the plaintiff's right of possession. I'm going to start with the second element, the element of entry. And the first reason the trespass claim fails is that plaintiff doesn't allege any entry on the property. She simply alleges that Mr. Bolding trespassed on the property, quote, by virtue of transferring shares in the company to another entity. But because, like I said, a trespass requires some physical invasion to real property, she doesn't meet this element and she can't meet this element. The second reason that the claim fails is that the plaintiff cannot establish that any physical entry was not authorized, because she actually pleads the exact opposite by admitting that at all times, Mr. Bolding owned some, if not all, the shares in the company that owned the property. And the third reason that the trespass claim fails is on the first element, which is plaintiff's ownership or right to possess the land. And I had created a timeline, but I can talk you through it. The gist of it is that plaintiff alleges any trespass occurred after she transferred all of her shares in the company to Mr. Bolding. She alleges that the transfer of her shares to Mr. Bolding happened sometime in 2019. And then she alleges that the transfer by Mr. Bolding to the other entity, she doesn't allege a date in her petition, but she alleges that it happened. And in the exhibits accompanying her petition at page 4 of Exhibit A, I believe, it shows that that transfer occurred in March of 2022. So again, any transfer, which is the purported trespass, occurred after she transferred all of her shares in the company. And so all of the allegations in the petition taken as true do not support a claim for trespass to land. And for this reason, the claim should be dismissed under Rule 91A. If Your Honor agrees, we do respectfully request the opportunity to address attorney's fees later on in the hearing. Thank you.
Okay, and I'm going to butcher your name, Mr. Let me see if I can do it. Adu Boafar, is that correct?
Dubofor. Yes, Your Honor.
Okay, somewhat close, right? All right, go ahead. And my biggest thing I want you to walk me through is from her statement is she started off with it, and the same question I had is number 2 about the physical entry. So, but go ahead, you can respond to her arguments.
Respectfully, Your Honor, thank you for the opportunity. And I will begin by saying that the motion is about the trespass to land cause of action, Your Honor. But
and that's all we're here about. That's all we're here about. Right?
That's true. That's true, Your Honor. But before we zero into that, the entirety of the pleadings per Rule 91A comes to play for Your Honor to consider when making a ruling on the motion they have brought. And so we want to go into portions of our pleading, and so to give the court an overview, an idea of why we brought that cause of.
Could you hold on? You skipped there. Could you repeat what you just said?
Okay, Your Honor, I'm saying that the issue here is Your Honor is suggesting that we limit it to the cause of action of trespass to land. In my response, I'm saying that before we narrow down that part, I want to talk about the pleadings we have before Your Honor. And the reason is that per Rule 91A, which is the basis for the motion that have been brought, the law requires that Your Honor takes into consideration the pleadings, all the pleadings and any exhibits thereto before you make a ruling. So I'm pointing out to Your Honor that number one, we are before your court invoking the jurisdiction of the court, not just the law jurisdiction, but the equitable jurisdiction of this court as well. And Your Honor, why do I say that? The court is a court of justice. And when the court sits as a court of law and as a court of equity. As a court of law, the court looks to what's on the face of the record to make a determination. What does the law say? Black letter. Is it there? Is it not there? That's a court of law. When Your Honor sits and the equitable jurisdiction of the court is invoked, what the party is pleading the court to do is to go beyond what's on the surface and look to see whether there's any truth of what is being asserted. And based on that inquiry that Your Honor will make a determination that would do justice to the parties. So to wrap up on this preliminary point, I'm saying we, as a plaintiff before Your Honor, we are invoking the equitable jurisdiction of this court as well, so Your Honor would understand the basis for which we come before you. Now, they made reference to having filed a similar lawsuit in Dallas. Your Honor, the Dallas court had no jurisdiction to determine land that is situated in Waller County anyway. So that issue of having filed it and having withdrawn that suit, I think it's really pointless. What it is whether or not we are properly before this court and whether or not this court has jurisdiction to determine the issues we have brought. Now, Your Honor, the basis, the facts that bring about the cause of action that we have alleged against the defendants are that the plaintiff and the defendant got together to start a company, which is the PV Asset Management LLC. The plaintiff, Your Honor, is a real estate mogul. That's what she does. She provided her services, brought her knowledge, brought her skill. And on the other end of the divide, the defendant brought land. They formed a company, transferred title in this property, title from that property to this company with the intent, and that's why we are invoking the equitable jurisdiction of this court, to look beyond what the paper is saying, with the intent that there will be co-owners, 50-50 shareholders, with the intent that the business will flourish and their efforts would generate for their mutual benefit as co-owners of the business. Your Honor, the parties operated along these lines, and if Your Honor would see, we exhibited a deed of easement that was signed by the plaintiff as co-owner. Your Honor, I will respectfully direct Your Honor to.
Let me kind of interject here,
Yes, Your Honor.
because you're taking this. This is the way I'm looking at your argument. I'm trying to get to what's going on in the city of Houston, and you're telling me how the earth was formed and how we're getting to the world. And, and I just think we need to cut to the chase here. As far as after you filed your, when you first filed your first pleading, all it was a trespass to try title issue. Then the defendant said 91A, There's not a trespass to try title issue, and these are my 3 reasons. Okay. Then you filed two amended petitions. You filed your second amended petition, which alleged a lot of other causes of action. Okay.
Yes, Your Honor.
I'm not saying, and the defendant is not even addressing those issues at this point. She might at a later date, but all we're here today is from what she just said and from her pleadings is we're not, you might have a breach of contract action. You might have a common law fraud action. You might have a fiduciary issue. You might have a promissory estoppel issue. You've pled all those things, but that's not what we're here today. And you're getting into all the discussion of their agreement and everything else. The question I have, it's simple. It's really one of law, and based upon the facts is this a trespass to try title case? That's all I'm deciding today. All right. Your case is not going to go away today because you amended your pleadings and you have all those other items that are before the court. So your lawsuit's still pending. The question is, do you have a trespass to try title case? And I'm having an issue finding that because of element number 2, which was brought up by the defense. And that's, if you could focus on that, because it says in element number 2 that there has to be a physical, oh hell, where is it? Let's see. Physically, intentionally, involuntary entering the property. The entry was, there has to be, to me, I can see a fraud issue claim because you're talking about shares. You're saying that your client owns title because of shares that were transferred that maybe, was fraudulently obtained in some way or whatever. But that cause of action is different than a trespass to try title. And I'm just having problems where, you're being able to claim that cause of action exists. So could you just focus on that for me?
Yes, Your Honor. Thank you. And the reason why I have to do what it appears Your Honor is not doesn't want me to do is that the interest we claim in this property is vested in us by virtue of adverse possession. Adverse possession. Trespass to title, we're talking about whether you have title to the land of which you are alleging that someone or you have physical possession of it, which you allege someone.
Hold on, let me stop you right there.
Yes, Your Honor.
Is there a counter petition alleging adverse possession?
Your Honor, we did not state it, we did not expressly state that, but we filed a response.
Hold on. Adverse possession wouldn't be a claim by you. It would be either a defense possibly or a claim by the person that has the property in title in their name. So are you trying to say that you have some claim for adverse possession as the plaintiff since the land's already been transferred?
Yeah, that's exactly what we are saying. We are saying that Your Honor, to begin with, adverse possession, you ought not to have title to be able to claim adverse possession. If you are on the land.
Hold on, just want to make sure. So you're claiming that your client there's an adverse possession claim by your client.
That's what we are setting, Your Honor. And on that basis, we are suing this cause of action of trespass to land, because we are saying that between us and them, we are entitled to, or we have a vested interest in this property. And Your Honor, all we are trying to say is, before the court summarily looks on the face of the record and says, I'm dismissing this cause of action, Your Honor must hear the parties, Your Honor must take evidence, so that at the end of the day, a ruling on whether or not that cause of action is proper, Your Honor, will be made. And that's what we are arguing. Our argument is simply that the 91A motion saying dismiss this cause of action, Your Honor, no, let that cause of action be tried together with all the other causes of action that have been asserted. If at the end of the trial, upon taking evidence, upon listening to the parties, upon considering all the law, the court comes to a determination that this plaintiff fails on this claim, Your Honor, so be it. But at this point, we respectfully assert that it will it would not be right that the cause of action that the plaintiff has brought will be dismissed. And our argument is that we have a vested interest in this property. To the extent that we have a vested interest in this property, we, and consistently the plaintiff has said, because of the vested interest we have in this property, the transfers that were done, the self-dealings that were done, all the issues that were done regarding this land, Your Honor, we consider and deem them as trespass to our interest in this land. Respectfully, Your Honor, that is why I kept going back into the transaction between the parties, the dealing between them, and how far they have come. So, Your Honor, I'm saying if we want to follow, or if Your Honor respectfully follows the argument that is being made by the movement to say, okay, there's no entry, okay, there's no physical possession, okay, there's no physical land ownership, so go away, go home. Your Honor, we saying that is incorrect. The court, before it looks to those simple elements, must determine the whole issue that the plaintiff has brought before Your Honor for justice, and look to them to see whether the claim that the plaintiff is making is valid. And so, in specific reference to the allegation they made that on the face of the paper, our client does not have title, or our client is not an owner on the face of the record, and to that extent, we have not satisfied an element of trespass to title. Our counter argument is that, yes, on the face of the paper, title does not belong to us, but we are asserting an adverse possession claim because we have a vested interest in the land. And that is our argument, that before the court summarily dismisses this claim or this cause of action, the court let it be, let a hearing be done, let evidence be taken, let the court come to the determination that all admissible evidence have been adduced before the court. And after the court analysis and everything, the court believes that plaintiff's claim has failed. That is a humble submission, Your Honor.
Okay. Any
Your
response?
Honor, do you understand my argument, or?
Well, I'm confused because I don't see anywhere in your second amended petition where you claim adverse possession. Are you claiming statutorily the 3-year, the 5-year, the 10-year, the 25-year adverse possession rules? Are you claiming under color of common law adverse possession? I mean, you know, I'm not seeing it in your pleading, but all I'm seeing in your pleading is trespass to try title. So, and usually I do a lot of adverse possession type lawsuits. Had one yesterday, in fact. But you know, the statutes are pretty clear on what elements it takes to be to qualify as an adverse possessor. And what's interesting about your claim is, you know, you're not on the land. If anything, you're trying to say the land was taken away from you. An adverse possessor is someone, in my mind, that's explain to me where I'm wrong on this, but you know, a person puts up a fence, open and notoriously says, don't, you know, I'm going to take over this land. They pay the taxes on the land. They're there 10, 20, 25 years or whatever. And then they come into the court and they say, hey, you know, this land is my land now because I've opened and notoriously, you know, been paying the taxes, doing everything, and the other person hadn't been around, or those are usually the arguments that I'm seeing here. What I'm hearing is that the land was basically, you know, from an allegation that the person or the defendant, I don't know, and you know, somehow got your client to give her the shares, and then after they owned the shares, they sold the property. So to me, that's more of a fraud type claim, or maybe one of the other, you know, allegate or cause of action that you put in your second amendment petition. But I'm not seeing where your client has an adverse possession claim. But you know, educate me again on where I'm missing that.
Respectfully, Your Honor, you asked whether our pleading we had adverse possession in it. in the second amended pleading, we did not expressly use the phrase adverse possession. But Your Honor, in the
Hold on. How is a fact finder going to know if the roadmap, because, a petition is the roadmap, you got to follow the roadmap to get to the pot of gold, right? To the order of the judgment, or to what you can go before a judge or a fact finder on, so they can make a decision. How do you not have, adverse possession in your pleadings, and you're here today saying, well, it's not expressly there? Well, it needs to expressly be there, right? I mean, how is the fact finder going to know that that's where we're going? But go ahead.
Your Honor, so that's number one. And number two, I'm saying that we filed a response to their reply on the 12th of this month. And in that response that we filed, we expressly asserted the issue of adverse possession. And even prior to that filing, we served supplemental disclosures, first supplemental disclosure to the defendant, and in telling them, as required by the rules, how we're going to calculate our damages, we asserted, and to their knowledge, that we're going to use adverse possession as the part of the basis for making those calculations. So, Your Honor, respectfully, what we are saying respectfully is that we have a vested interest in this land. And to the extent that we have a vested interest in that land, we are making an adverse possession claim. And based on that adverse possession, we are saying that the court should look beyond the
well, hold on, I'm still confused, because that statement kind of looks like you're saying they wrongly adverse possessed the property. But adverse possession law is when you're trying to claim, in my understanding, maybe I'm just missing it totally. Adverse possession law is when you're saying, no, I've been on the land for all this time, and you need to award me the property because I'm adversely possessing it. But your argument is that the other side has adversely possessed it? Maybe,
No, Your
maybe
Honor.
I'm not understanding your
Okay.
definition of adverse possession.
Because, Your Honor, the land as it sits there are projects that plaintiff and defendants were doing on the land. So it's not like just a land that is somewhere there, but it's a land.
Real quick, you can fix my question in this way. Who, in your opinion, or who adversely possessed the land? Your client or the other party?
We are making a claim of adverse possession on our part.
You're claiming your client adversely possessed the land.
Yes, Your Honor. And the reason, and the basis for that claim is that we have been ousted, right? We've been outside, and so they're having a jolly ride. But we are maintaining that we have a vested right in that land because our industry has gone in, our resources have gone in. We have an equitable title to an interest in that property. And that is why we are saying that the court should determine the matter as a whole, because, right, Your Honor, like you rightly said, we have claimed common law fraud. We are claiming.
Quick, as to the adverse possession claim, do you have any case law of a similar type, argument where this has happened, where an adverse possession claim has been made in a situation similar to this? Do you have any case law that supports your argument?
Your Honor, the case law I have is not specifically the same as we are urging the court, but the law is clear that to assert an adverse possession, you must make a claim of right that is inconsistent and hostile to the claim of the person alleging to be the owner. And that's what we are doing here. We are articulating, we are forcefully saying, making a claim that it's inconsistent with theirs. I mean, they have the title, they claim the land is theirs, but we are saying that we have a claim and we are vehemently making this claim. It is inconsistent with their right of usage as the title holders of the land. But our assertion is deeply rooted in the fact that we vested our resources, we vested our sweat, we vested our knowledge, we vested everything we had into the project that's going on that land. And to that extent, we have a vested interest. And
I'm
we are
not-
making,
Go ahead.
and we are making this claim saying, before Your Honor goes ahead to say, I'm dismissing this course of action, all the evidence, all the material witnesses must be heard, must be seen, must be examined before the court arrives at that. And that cannot be done on a motion, a 91A motion, Your Honor. So we are saying that we should go beyond just a motion to dismiss the course of action, but do a trial or hearing for that matter, get evidence into the record to establish whether or not the claims we assert do exist. We respectfully say they do exist. We have evidence to support that they do exist, but not all of it can be poured in a hearing for a motion. And it's for that very reason that we are respectfully asking Your Honor to decline this motion and let the matter be heard on its merit.
Okay. Ms. Curry, any response?
Yes, Your Honor, briefly. I heard a lot of things, but I did not hear analysis on any of the elements that I identified to you were deficient. We've got a pleading that does not raise any of the theories that plaintiff's counsel is trying to bring in at this point. Again, no physical injury is alleged. That's dispositive. The entry, if at all, could not have been unauthorized. That's dispositive. If I humor plaintiff's counsel for just a second, I would say Rule 91A exists for a reason. He is correct that you cannot consider evidence at this point, but we have this rule so that baseless claims can be dismissed early without expending time and money on defending them. And then lastly, the theory of adverse possession is raised for the very first time on Monday. The theory is not in any petition with you. I'm just as confused by it, but I will say that it is inconsistent. The theory of adverse possession, which is the process by which a trespasser gets title to property, is entirely inconsistent with what is in the petition, which is that plaintiff owned stake in the property or owned the property by virtue of her stake in the company. And so with that, is all I have on the.
Okay. Any response, Mr. I apologize. It's Abdul-Bafor?
Yes, Your Honor.
All right. You want to make
any response to what he said? Well, Your Honor, respectfully, we believe that our position has been clearly stated to the court. And in sum, what we are saying is that this course of action, trespass to land, is not standing in isolation. This course of action that we have asserted is inclusive of about several course of action we have put in there, including common law fraud we are setting, including constructive trust we are setting. And Your Honor, if you look, including breach of trust, if you look at it,
those issues are still there, man. I mean, and I didn't mean to interrupt, but go ahead. You've been finished.
I'm sorry, Your Honor.
You can continue. I shouldn't have interrupted you. Go ahead, finish.
Okay, Your Honor. So our submission is that the facts that ground these causes of actions are not in isolation. They are together. And so before the court will hasten to say, I'm taking out this cause of action, we respectfully urge the court to not do so at this moment, but let the case be, let trial be done, let evidence be taken, because we have witnesses, we have documentary evidence, we have video evidence, we have several materials we will put before the court to prove to the court that that cause of action we assert is valid, it's a valid claim we are making. And so at this point, respectfully, Your Honor, at this point, all we are arguing is that the court does not dismiss this cause of action at this time, because we ought to be given the opportunity to present all our evidence to the court, for the court to go beyond just what the paper is saying, what the title, or they have title to this land, has anyone entered it? Those are just what is apparent on the face of the record. And that's why I began my submission by saying that we are equally invoking the equitable jurisdiction of the court to go beyond what's on the paper and to inquire into the allegations we are making, whether there's any basis. And when the court does that, the court will come to a determination that we have a valid claim, including this trespass to land cause of action we have said.
Okay. All right. Well, let me go ahead and make my ruling, and then we can talk about attorney's fees after that. This is the way I see it. 91A was brought into play because it was trying to narrow lawsuits so that we didn't have shotgun litigation. Okay. Same with motions for summary judgment, coming there to get it narrowed down. So when the fact finder has to make a decision, if certain causes of action are pled that just have no merit, then that kind of gets them out of the way. And to me, it's like, let me give you an example. You said, well, this is all combined and we need to let it flow, and let me just, we'll find out on the back end. Well, I don't think the trespass to try title would be any different than if you'd have pled, medical malpractice in this lawsuit, right? Because, medical malpractice, doesn't exist in this lawsuit, right? So I got to decide whether trespass to try title does. Similar to, and as far as, let's talk about your adverse possession claim as well. First of all, that's not even before us today. You made an argument, you said in a pleading, I want to say, that you recently filed, but it's not in your original petition or your amended petition. And so the roadmap says nothing about adverse possession. And adverse possession, is a separate cause of action than trespass to try title. Okay. So in my mind, that's not even before us today. So when I look at your trespass to try title elements of that claim, just like if you had a medical malpractice claim here, elements of that, since that wouldn't apply, I don't think you make it. And I don't even have to go to 1 or 3 or whatever it is, but 2 in and of itself requires that that there'd be entry on the land, physical, intentional, voluntary, and unauthorized entry. And to me, you're saying that the land was wrongly placed through shares, possibly that was fraudulently occurred in some way. That's how you get to a land dispute here. And that's an asset of shares. So I'm just not seeing trespass to try title. If you want to amend and claim adverse possession, you can do that. I'm not seeing that at this point, but maybe you can educate me. You've provided me no case law that supports your argument. And you're basically saying that pretty much doesn't exist, as from what I'm hearing. So with that said, I try to stay between the lines. I try to look at the elements. I'm just not seeing a trespass to try title here. Now, with that said, and the defendant counsel has even said this, we're not talking about your other causes of action. Your lawsuit's not dead. All your other causes of action are still in play. And the only thing that I don't think should be here today, and I agree with the defendant, is this trespass to try title, because I don't think, even if I allowed it and we took this to a fact finder, whether it be me or a jury, that's not going to come in before that fact finder, because you can't meet the elements of the lawsuit. Okay, so that's the way I see it. As far as attorney's fees, we can talk about it, but this is the way I feel about that. And we can put on the evidence if you want to preserve it. But anytime someone files a lawsuit, sometimes it's hard to get your hand around what all needs to be filed. I get that. I'm not inclined to award attorney's fees at this point. So that's kind of where I am on that. But if Ms. Curry, if you want to put that on and have the opportunity to do that because you feel like your client, you need to advocate for your client, I'll let you do that. But I mean, I'm telling you right now, I'm probably not going to grant them. So it's up to you.
Sure. I think we will let the attorney's fees piece of this go. I do respect that inclination of yours. I want to clarify one thing, if I can.
Sure.
We have asked for the trespass claim to be dismissed with prejudice, that claim. And so I'm hoping that we can talk
Yeah, I'll
about the
dismiss
nature of
that claim with prejudice, but I'm looking at your order. What I'm not gonna have in there, obviously, is the attorney fees I'm gonna take out, but where you say it is therefore ordered that the action is dismissed in its entirety, yeah, that's not gonna happen, but I
That's
will.
correct.
dismiss-
That was a mistake.
Yeah, in fact, why don't you do this? Why don't you amend your order? That way it'll look a little bit nicer. It says that, I'm only dismissing the trespass to try title action and only that action with prejudice and not awarding attorney's fees, but everything else will continue to, kick that can down the road as far as the rest of the lawsuit. Okay? All right,
I will
so
get that.
does everybody understand my ruling?
Your Honor, for purpose of clarity, my understanding is that you are dismissing the cause of action of trespass to title,
Only.
but only. That's number
Okay.
one. And number two is not being dismissed with prejudice, being dismissed without prejudice.
No, it's being dismissed with prejudice. And if you think I'm wrong, I have no problem. I never want to be a court of appeals judge because that's above my pay grade. So if you think I got it wrong, then you definitely can take me up and I'll honor their decision. But I think I'm pretty much right on this. So it's up to you. But I think your cause of action is more in some of the other, cause of action that you pled in your second amended petition. I think you're on the right track on that. I agree with the defense. I just don't see a trespass to try title in this lawsuit. But hey, it's like there are other, so maybe other minds will differ and see it differently if you do take it up, and it doesn't offend me when attorneys do that. But that's my understanding and interpretation of the law, and so that's what we're going to go with. Did you have any other questions? I'm not awarding attorney's fees. Really, the only issue today was, I know you want to talk about, kind of the whole case here. But the reality is we were here for two issues, attorney's fees, which I'm denying, and whether the trespass to try title lawsuit should go forward. And since the elements in my mind can never be met, then that's why I'm denying that or granting their motion to dismiss that issue of the lawsuit. Okay. All right. So if you'll redo the order, Mrs. Curry, and get it to me, I will sign it. And have you guys, I don't even know where y'all are in y'all's case. When was this case originally filed?
Well, I can give you an update on that. The case was filed in September, and we timely answered it after. Relatively new, yes. We've served request for production, request for admission, and interrogatories on plaintiff. Those responses are due on December 22nd. We've also asked for deposition dates.
And it's my understanding y'all went to an arbitration at some point. So it sounds like to me mediation is not really an option. I don't want to ever send people to mediation if they're just going to go there and spend money. So it sounds like to me neither of you guys think that y'all can mediate this. Is that correct?
I don't believe so. And in fact, I think you might anticipate seeing us again on another motion to dismiss at least some of the new claims. I think we can dispose of a lot of this case on preliminary motions. Okay.
The other issue, so a lot of people don't know this. I am in a rural community. Okay, so I'm a court of general jurisdiction. Okay, so I don't just handle civil cases. I handle, criminal cases, tax suits for the county. So my docket's pretty full, and I'm the only district judge in the county. Okay. I also am not just working in this county. My bench also covers Grimes County, and 40% of my efforts, I guess, go to Grimes County. So what I'm telling you is they got me with Waller County just exploding. Okay. We are predicted to double in size in the next 2 to 5 years. Okay. So we just hit right at around 50 to 60,000 folks, and subdivisions are coming in like crazy. And just so you'll know, that we're talking with our legislator, trying to get another bench for me to help me. I'm feeling pretty comfortable about it. Both the senators in our district are really pushing for it, and they're pretty big hitters. And so I'm feeling comfortable that we will get it, but it might not go online for 2 years. So many a day, I feel like the little kid and holding his finger in the dike, just trying to keep the dam from breaking. I am fortunate enough to have the gentleman that I replaced as a senior judge now, Judge McKay, and he has been gracious enough on occasion to come in. And when I'm in Grimes County, he'll come and try some cases here. And I'm trying cases like you wouldn't believe, with all the tax dockets and civil hearings and motions to suppress. I try to at least get one trial done a week, and I sometimes I try to schedule a couple, obviously, but things are going to get ready to get worse for me. I was literally planning on trying, and you're all aware of this, but my sister is the county court at law judge. We're the only brother and sister team in the state of Texas. So I convinced her, I told her I was going to tell mom if she didn't give me some of her court time, because she's not using it. And I was going to go over to the courthouse over, that was a joke, by the way, it went over. But she was going to graciously let me use some of her court space so I could bring Judge McKeg over here to get some of these civil cases out of the way, because I have to pref set murder and sexual assault of children cases. And unfortunately, we have a lot of those. And so I've been down here 8 o'clock at night. The lights shut off. I've had juries tell them, okay, I got another jury coming in Monday. You guys got to decide it now, and they'll be working with my bailiff's flashlights to get cases resolved. Thought I could get some relief to the civil side this next year, because I set my dockets out a year in advance. But we're handed some really, really bad news. The old courthouse foundation is in such disrepair that they're condemning the building. And so guess she's coming over to this new courtroom. So now I gotta, even though I was gonna get some of her space, now I gotta give up some of my time so she can get her family law stuff and stuff done. So things have gotten worse for you guys than better. So with that said, I just tell you to bear with me, but I have over 1,100 active felony cases just in Waller County, doesn't count Grimes, and over 1,500 active civil cases. I was only able to get one civil case trial done last year. Okay. So, if you guys can work it out, great. If you want a bench trial, I can probably work you in, but most people want a jury trial. And if that's the case, you guys are kind of the low man on the totem pole. Now, I will say, I always put a civil case at the bottom, and how my docket works for trial week is because I was lucky. I did not lose any juries. Well, I lost one jury panel last year because of a COVID incident. But other than that, I average about 20 on the docket, and everybody has to be ready to go. And I always usually have 2 or 3 civil cases, and I tell them they need ready to go. And I have 3 prosecutors that I'm given, and each prosecutor has either a murder or a sexual assault case. Okay. And I take those first. And then each prosecutor has 2 other cases that are either possession cases, credit card fraud, less intense. And so I go down the list, and I try to work this. If it's not a murder or sexual assault case, I try to work the civil cases in there on occasion. But the reality is, what has happened is I might have all 20 cases plead, right? And I'll go to the civil people, and they look at me like, you were serious about being prepared. We need a continuance. We're not ready. We thought we were 20th, and now we're ready to go. We can't do it. Okay. And so, but luckily, like I said, I've always been able to find a defense attorney and a prosecutor that can give some case to try. And so, I always tell the civil guys, okay, you might be looking like you're 20 on the docket, but and that's really sucks for you guys, because, it's really what happens is, and it's just human nature. You'll get a copy of my docket, and you'll talk to my coordinator, and you're like, oh, hell, they're not going to get to us. There's no way. And then the next thing, I'm like, let's go. And, and both sides, you can just see the deer in the headlight look, so just be aware of that. But it really sucks for you guys, because you might get all prepped, ready to go. And then I'm taking the murder case, or I'm taking the possession case, or whatever, so just giving you heads up on how my world works. And we've tweaked it. the judge before me, I mean, I was blessed. You know, the guy tried to tweak it every which way to make it work better. This has worked better. I've tried to tweak it and come back to what he did, because I should have realized the guy is probably a lot smarter than I'll ever be. But his coordinator and staff are here, and they've educated me on how they tried to tweak it in the past and hadn't worked. And this is probably the better way. And I agree with them totally now. So with that said, you know, I'll get off my soapbox and my, y'all are like my therapy today. I can complain about all the work I have, but I'm probably preaching to the choir. I'm sure y'all are all. But with that said, so if you know, that's where we are. So if y'all get your discovery done, I suggest you try to get on the docket as quickly as you can, because you know, I have, like I said, 1,500 other civil cases. The faster you get on the docket, the better you have a chance to at least get in the system and try to get to you. Okay.
Okay, Your Honor.
Well, we
All right.
appreciate you setting aside time this morning outside your regular time. We appreciate
Not a
that.
problem. All right, so I'm gonna let you guys go. If again, Ms. Curry, give me that order and I'll get it signed. And you guys have happy holidays. All right, bye,
Thank
guys.
you.
Thanks.
Bye, Your Honor.